Good evening, all. Sharada Krishna Sadgamaya Foundation for Law and Justice is a charitable foundation founded by Justice Kirshnaiyer in the year 1992. We were conducting law lectures in every year on different legal and academical subjects. And after the sad demise of our founder in the year 2014, we are conducting memorial law lectures. This is the 7th memorial law lecture, and that with a very significant topic, revisiting social justice jurisprudence in post-Krishnayer era. I request Justice K. Balakrishnan Iyer, President of the Foundation, to welcome the gathering. Sir.
Thank you. Justice Kirshnaiyer needs no introduction. He was a living legend of law, an embodiment of justice, compassion, and integrity, and everything that can be said about a human being. This law lecture held every year in his memory is one of the important things done by the foundation, Sharada Krishna Sadgamaya Foundation, founded by him to keep his memory alive. Of course, even without these formal lectures, he lives in the hearts of the poor, downtrodden, and the progressive-minded people of India. The subject of this lecture, pointed out by Dr. Pradeep, is social justice, revisiting social justice jurisprudence in post-Krishnayer era. Justice L. Nageswara Rao, Judge of the Supreme Court, has kindly considered to deliver this serious lecture. We consider as a real fortunate thing. His Lordship has readily agreed upon being approached by the office bearers of this foundation. His Lordship was an eminent lawyer, having practiced in various high courts and also Supreme Court. And he is the 7th person to be elevated directly to the Supreme Court from the bar. And he has rendered several judgments, epoch-making judgments, if I may say so. And one of them is the decision in Madras Bar Association case. The function is presided over by Manikumar, the Chief Justice of the Kerala High Court. After a successful career at the bar, his Lordship was elevated to the bench of the Madras High Court in 2006. And in 2019, he was transferred as the Chief Justice of Kerala High Court. And we are fortunate to have him as the President of the last two law lectures also. This is the third time his Lordship is presiding over this. The formal duty assigned to me is to welcome the participants. I formally welcome Honorable Mr. Justice S. Manikumar, the Honorable Chief Justice of the High Court of Kerala, to this function. And I also welcome His Lordship L. Nageswara Rao, Judge of Supreme Court, to deliver this year's law lecture on the subject, Revisiting Social Justice Jurisprudence in Post-Krishna. I also welcome all those who are watching this function through the YouTube. Thank you all. Thank you very much.
I welcome Justice S. Manikumar for having the president's speech for this function. Please, sir.
Respected Honorable Justice Nageswara Rao, Judge Supreme Court of India, Justice Balakrishna Iyer, former Judge, High Court of Kerala and President of the Foundation, my esteemed brother and sister judges, esteemed former judges of this court, Advocate Dr. Pradeep, Secretary and Office Bearers of the Foundation, learned judicial officers, respected senior lawyers, my dear junior lawyers, ladies and gentlemen who have joined us today online. Good evening to you all. I am thankful to Sarada Krishna Satmaya Foundation for Law and Justice to have given me an opportunity to be a part of this commemorative program, paying tribute to a great judge of this country, Justice Kirshnaiyer, in the presence of a scholarly judge, Honorable Justice Nageswara Rao, Judge Supreme Court of India. Social justice is an integral part of justice in a generic sense. Justice is a genus of a social justice is one of its species. Concept of social justice has different dimensions. Diversities in the society, economy, deep-rooted religious, cultural, and traditional value-based influences on the social life are sometimes taken as determining factors to design the ambit of social justice. The Preamble and various articles contained in Part 4 of the Constitution promote social justice so that life of every individual becomes meaningful, guaranteeing right to life with human dignity. We cannot forget the forefathers of the philosophy of legal aid, Justice Kirshnaiyer and Justice P.N. Behawadi, who in 1980 paved the way for public interest litigation movement in India by giving a wide meaning to the words locus standi, whereby people of India have a chance to access to justice. Justice Kirshnaiyer played a very significant role in molding the era of judicial activism to protect the rights, liberty, and justice to people, in particular the poor, weaker, and the marginalized sections of the society. Constitutional power of judicial review was potentially used by him as a weapon to promote public interest litigations, affirmative actions, and thus preserving the constitutional values of liberty and justice. Justice in all its forms, social, political, and economic, were promoted and preserved in his judicial verdicts. Through his judgments, he preserved the concept of social justice as an important jurisprudential thought, maintained human right-based analysis of social justice. It is from his era, in the Honorable Supreme Court, we have witnessed several instances importing human rights value to personal liberty. He redefined the scope of the rights of the prisoners, directing prison reforms in Sunil Batra, rights of the laborers in Bangalore water supply, fair treatment for undeterred prisoners in Prem Shankar Shukla, and distributive justice in Ratlam municipality. He even started the trend for the judges to go to the field and see the actual ground realities, to see the life of a common man, rather than sitting in the courtroom as interpreters of law. Justice Krishna and Shamlal Murari observed that the technicalities barring effectiveness in justice dispensation have to be ignored. He said, I quote, "We must always remember that process law is not to be a tyrant, but a servant, not an obstruction, but an aid to justice." He added that procedural prescriptions in law can only be a lubricant, not a resistant in administration of justice. About Justice Krishna, I would like to quote a few words by Mr. Solly Surabji, a great jurist, on the multiple achievements of Justice Krishna. I quote, "There are judges who are more erudite than Justice Krishna. Judges who have an excellent memory for Supreme Court and House of Lords citations. Judges who can master the record of a case in few minutes. But the one essential quality that distinguishes him from his judicial brethren and puts him in a class of his own is compassion. He took human suffering seriously and dispensed justice with compassion, which he possessed in abundance." When Mr. Fali Nariman was invited to speak on the pathfinders in the Supreme Court, he named only two judges, Chief Justice Subba Rao and Justice Kirshnaiyer. In his autobiography, Fali Nariman wrote, I quote, "While Subba Rao had an obsessive concern with fundamental rights, Krishna's concern was broader for the poor and the downtrodden. We may not have a rebirth of Justice Krishna or another Krishna in the judicial history of India. Krishna will be remembered forever for his remarkable involvement in the promotion of judicial system, social justice, and reforms in law." Before concluding, I once again express my sincere gratitude to the office bearers of the foundation for giving me an opportunity. Looking forward and eager to hear respectable Honorable Justice Nageswara Rao, at Supreme Court of India, on the topic. Thank you. Thank you.
Thank you, Chief Justice S. Manikumar, for the presidential address. This is the 7th Memorial Law Lecture in remembrance of our founder, Justice V.R. Kirshnaiyer. We are blessed with the presence of an erudite jurist, Justice N. L. Nageswara Rao, for rendering the 7th Memorial Law Lecture in remembrance of Justice V.R. Kirshnaiyer. I request Justice L. Nageswara Rao to render the speech. Please, sir.
Justice Manikumar, Chief Justice of the Kerala High Court, Justice Balakrishna Iyer, the President of the Sarada Krishna Sadgamaya Foundation for Law and Justice, Dr. Pradeep and other office bearers of the association, judges of the High Court, both sitting and retired, members of the legal profession, and other viewers of today's program. Good evening. At the outset, I deem it an honor to be invited to speak today in the 7th Memorial Lecture, which is organized by Sarada Krishna Sadgamaya Foundation for Law and Justice, especially on a topic which was very close to Justice Krishnayer's heart. John Rawls, in his theory of justice, says that the theory of social justice is just distribution of primary social goods. Social goods are things that every rational man needs. Every person has the same and indefeasible claim to a fully adequate scheme of equal basic liberties, which scheme is compatible with the same scheme of the liberties of all, according to John Rawls. How did this theory all start? In the 13th century, an Italian thinker, Thomas Aquinas, said that in addition to do the right thing, we should strive to do whatever is necessary for the betterment of others. This was taken forward by another Italian jurist, Luigi Tapparelli, who introduced social justice as an economic aspect. In his own words, Justice Iyer said that there must not be judges who are untroubled by the miseries of the masses. In 1776, the Declaration of Independence was made, and Thomas Jefferson said on that occasion that, I quote, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights, that among those are life, liberty, and pursuit of happiness." The preamble of the American Constitution includes that a constitution was being made to promote general welfare and secure the blessings of liberty. What happened thereafter? After it was declared during the Constitution, which was made in 1776 to 1779, that there would be liberty, equality for everybody. In the infamous judgment of the US Supreme Court in Dred Scott versus Sanford, the Supreme Court, in a judgment of 7-2, and the majority written by Chief Justice Roger Taney, held that citizens in America of African descent are not citizens within the meaning of the Constitution, and slavery was upheld. Out of 32 million people, there were 4 million blacks who were slaves in the United States of America at that time. After the judgment in Dred Scott in 1857, there was an amendment that was proposed to be made, which ultimately came through by the 13th Amendment to the American Constitution, by which slavery was abolished. There was bloodshed. The American Civil War took place for a period of 2 years between 1860 to 1862. Persons who were supporting the federal structure, who were in the northern part of America, had to take on persons from the southern part of America who wanted to secede on this ground of abolition of slavery. There was a war, and it was one of the bloodiest wars. About 750,000 soldiers died, apart from uncounted number of civilians being killed. But there was an amendment to the 13th Amendment as well as the 14th Amendment, which were brought in. Abraham Lincoln was assassinated thereafter. Even after the amendment, was there a change? In 1898, by mistake, one Plessy entered into a railway carriage which was reserved for whites only. He was prosecuted for traveling in a carriage which was not permitted for the blacks and convicted for an offense. He challenged the act which made it an offense. And the act was upheld till the Supreme Court on the principle separate but equal. They said it's all right. Blacks are also citizens of the country, but they cannot be treated. They should be treated separately. It took a long time for correction till the Brown versus Board of Education judgment came in the US. All persons are treated as equal, sans their race, ethnicism, etc. But in practice, whether this is really being done is something which is a matter of perception. Pandit Nehru was a socialist. When the Constituent Assembly was meeting to frame the Constitution, he said, the first task of the Constituent Assembly is to free India through a new Constitution, feed the starving people, and to clothe the naked masses, and to give every Indian the fullest opportunity to develop himself according to his capacity. In the speech delivered by him on 22nd of January 1947, he said in a quote, the first task of this assembly is to free India through a new constitution, to feed the starving people. This is certainly a great task. Look at India today. This was in 1947. We are sitting here and there is despair in many places and unrest in many cities. The atmosphere is surcharged with these quarrels and feuds which are called communal disturbances, and unfortunately we sometimes cannot avoid them. But at present, the greatest and most important question in India is how to solve the problem of the poor and starving. Wherever we turn, we are confronted with this problem. If we cannot solve this problem soon, all our paper constitutions will become useless and purposeless. It took more than a period of 2 years for deliberations that were made by those scholarly people who were the founding fathers of the nation to finalize the document, which is the Gita, Bible and Quran, for a secular India, which is the Constitution of India. In his speech delivered on 25th of November 1949, Baba Saheb Ambedkar said that we must make our political democracy a social democracy as well. Political democracy cannot last unless there lies at the base of its social democracy. What does social democracy mean? It means a way of life which recognizes liberty, equality, and fraternity as the principles of life. These principles of liberty, equality, and fraternity are not to be treated as separate items in a trinity, They form a union of Trinity in the sense that to diverse one from the other is to defeat the very purpose of democracy. On the social plane, Dr. Ambedkar said, we have in India a society based on the principles of graded inequality, which elevation for some and degradation for others. On the economic plane, we have a society in which there are some who have immense wealth as against many who live in abject poverty. On 26th of January 1950, we are going to enter into a life of contradictions, is what Dr. Ambedkar said. In politics, we will have equality, and in social and economic life, we will have inequality. In politics, we will be recognizing the people of one man, one vote, and one vote, one value. In our social and economic life, we shall, by reason of our social and economic structure, continue to deny the principle of one man, one value. How long shall we continue to live this life of contradictions? Was the agony of Dr. Ambedkar. How long shall we continue to deny equality in our social and economic life? If we continue to deny it for long, we will do so by putting our political democracy in peril. We must remove this contradiction at the earliest possible moment, or else those who suffer from inequality will blow up the structure of political democracy which this assembly has laboriously built. On 26th of January 1950, the Constitution of India came into effect. That is the Republic Day that we celebrate, on which day we, the people of India, having solemnly resolved to constitute India into a sovereign democratic republic as it stood then, and as a sovereign socialist secular democratic republic after the 42nd Amendment, and secure to its citizens justice, social, economic, and political, is what the preamble says, along with liberty, equality, and fraternity. This is the constitution that we have given to ourselves. Justice Kirshnaiyer wrote an article where he said, who are these we the people of India? Do they include all those persons who do not have the same rights and liberties, who do not have the wherewithal to demand for inclusion in the society, who demand for equality? The constitution makers have categorically put justice, social, economic, and political in the order of preference in the preamble itself, which is a torchbearer to the document which we call the Constitution of India. It comes even before liberty, equality, and fraternity. Justice, social, economic, and political is not justice that is delivered by court, as they use in common parlance. Justice is distributive as well as retributive. Distributive justice is flowing from what the other branches of the government have to do. That is, providing access to resources by the government to all the needy persons. There are 5 principles of social justice, and these principles are access to justice, equity, participation of parity, diversity, and human rights. We look at the directive principles of state policy, which is in Part 4 of the Constitution of India. Though Article 37 says that these principles in the part shall not be enforced by any court, but these principles in Part 4 are fundamental to the governance of the country, and it shall be the duty of the state to apply these principles in making laws. So any laws that are made should be taken into account, should contain the philosophy that is there in the directive principles. Article 39 of the Constitution of India refers to the right to adequate means of livelihood for all citizens, men and women, the ownership and control of material resources of the community, and the distribution of those resources to subserve the common good. Operation of an economic system which does not result in concentration of wealth and means of production to the common detriment. The health and strength of workers, men and women, in the tender age of the children are not abused. The other articles that are found in the directive principles of state policy include Article 41, which speaks of right to work, to education, and public assistance in certain cases. 42, which talks about provision for just and humane conditions of work and maternity relief. Living wages for workers is dealt with in Article 43. Article 45, which refers to provision for early childhood care and education to children below age of 6 years, and promotion of educational and economic interests of scheduled castes, scheduled tribes, and other weaker sections being dealt with in Article 46 and Article 47, which imposes a duty on the state to raise the level of nutrition and standard of living and to improve public health. To ensure that this country is a welfare state, these are the obligations that are cast on the government of the day. Part 3 of the Constitution deals with fundamental rights. And the rights that are dealt with of individuals in Part 3 of the Constitution also point to the importance that is given by the Constitution makers to social justice as a concept, and social justice to be achieved in this country. Article 14 of the Constitution of India refers to right to equality and equal protection of laws. Law has to be equally administered, forgetting about the caste, creed, religion, the region of a person. Article 15 provides for affirmative action by the government for the purpose of uplifting the underprivileged and the downtrodden by providing them opportunities. The same extends to Article 16. By Article 17, Untouchability, which has been an age-old practice by which the downtrodden people were crushed under the iron feet of the rich and the mighty people who belong to the higher classes for ages was abolished and it was made an offense. Article 21, which is a shining star in the constellation of rights provided to citizens by the Constitution, refers to right to life, the scope of which has been enhanced by judicial interpretation. And Article 23, by which bonded labor has been abolished. There are rights that are given to the minorities, both religious and linguistic, apart from the right to religion that has also been guaranteed to every citizen of this country. Another very important right that is guaranteed is Article 32, for people to approach the court for violation of fundamental rights. After the Constitution has been put in place with the framework providing for the administration of justice by the courts and the distributive justice by the governments, the executive as well as the legislature, by laws being made and implemented to take care of the poor and needy and to bring an egalitarian society. The advent of Justice Kirshnaiyer was a refreshing change, as the agrarian reforms which were sought to be made by the government were interfered with by the court on interpretation of the provisions of the Constitution after in the initial days in 1950s and 1960s, which we need not go into on this evening. But what is relevant for the present purpose is about the reaction of the judiciary in promoting social justice. The topic for today's discussion is revisiting social justice jurisprudence in post-Krishna era. Till now, I was speaking about pre-Krishnaiyer era as to what the philosophy of social justice is and how is it that it has developed in this country, and how is it was in the Constitution till his advent. After his foray directly in service of the people by being a politician and a minister, Justice Kirshnaiyer, in his short stint at Kerala, in the Kerala High Court for a period of 5 years, served for a further period of 7 years in the Supreme Court. He delivered landmark judgments and is considered to be one of the greatest jurists this country had. His concern for the underprivileged and depressed sections of the society is unmatched. Chief Justice Manikumar referred to some judgments that were delivered by Justice Iyer. Justice Iyer mainly spoke about justice to the underprivileged people by providing them access to courts to get their voice heard. He, in Municipal Council Ratlam, said that courts should take affirmative action to make the remedy effective and not play the role of an umpire. So apart from adjudication of disputes as is done in this adversarial system, which we follow from the Westminster system from England, with which Justice Kirshnaiyer did not really agree. He wanted proactive judiciary to help such of those persons who were not getting justice. Justice doesn't mean only entering courts, who were not being treated equally along with the other citizens, not being provided an opportunity to develop themselves equally along with all the other privileged persons. And also people not having access to the material resources and not even having access to basic amenities of life, and people who are living in squalor and penury. These were the persons who were very close to his heart, for whose rights he was always fighting for, even as a judge. He dealt with the reservations, which is an aspect of participatory parity, with which I'll be dealing a little later. In Thomas as well as Akhil Bharatiya Soshit Karamchari Sangh, he dealt with this aspect of reservations of Article 14, 15 and 16. He was considerate to women's rights in a judgment of C.B. Muthama, who was an IFS officer. He wrote about the rights of women as to why there should not be gender equality. Why is it that the women are discriminated in comparison to the men? He was very passionate about prisoners' rights. His judgments in Idiga Annamma as well as Rajendra Prasad are judgments which we refer to as and when we hear cases of death sentences as well as life imprisonments, whenever those cases come to us. And day in and day out, when we deal with bail applications, members of the bar remind us of what he said in Gudikanti Narasimhulu, that bail is the rule and jail is an exception. And access to justice, which he dealt with in detail as to how important it is in Darshana Devi. He delivered innumerable number of lectures and wrote articles apart from the books that were published, which are very popular, on rights of the impoverished people in this country and the need for action by all branches of the government, including the judiciary, in protecting those rights. Before I deal with how the judiciary has taken forward the vision of Justice Kirshnaiyer in providing social justice, I would like to say a few words on what I understand about social justice. I already said that the 5 principles of social justice are access to resources, equity, participation, diversity, and human rights. Access to resources. Access to resources is a basic thing, which is what was being called as redistributive justice. Redistribution is done by providing all basic amenities to every citizen in this country. That's how redistributive justice is understood as. Every citizen of this country has a right to be provided what every rational man needs for his living. What are those? Food, shelter, clothing, protection of health, education, and the other liberties which are spoken of about equality, etc. This is access which has to be provided for distributive justice. The second one is equity. Equity is different from equality. Equality, as is dealt with in Article 14, is every person has a right to be treated as an equal, which means that he should not be discriminated against. Every person is equal in the eyes of law in this country. And equal opportunity has to be given to everybody in matters of any privilege, any employment, and any facility that is to be given. There shouldn't be any discrimination. That is equality. And what is equity? Equity is the affirmative action which we are speaking about, which the government has power under Article 15 and Article 16 of the Constitution of India. Equity is identifying people who need support for the purpose of making them on par with the others so that they can compete with the others. That is the equity jurisprudence. Participation. Apart from redistribution, parity of participation is one very important aspect of social justice. As I was reading out from the lecture of Baba Saheb Ambedkar on 25th of November 1949, he was speaking of political equality, one person being given one vote and one vote having one value. That is political equality. But participation parity is this. There are groups of the majority and groups of the marginalized sections of the society who need help, who need assistance. Persons belonging to the marginalized sections of the society have to be given an opportunity to man those posts to take decisions, because they are the best persons to know what are the needs of persons who are not getting justice. So they should be at the helm of affairs along with the others, and recognition of the difficulties faced by those groups are taken care of, because they would be amongst the decision makers. When reservations are provided for in the Constitution, the idea is to provide education, idea is to provide employment, and by this, persons would develop as individuals, as well as they would grow to be at the helm of affairs, and they would also provide opportunities for other persons belonging to the downtrodden sections of the society, so that their needs are addressed suitably. That is participation parity. Mere access to resources is not sufficient if you want to uplift the sections of society which are disadvantaged in this country. The fourth principle, which is diversity. The decision makers have to understand that this country has thousands and thousands of castes. This country has so many divisions of sections of the society living in different parts of this country. We have such a large country, and the diversity of culture and the requirements of people coming from a diverse sections of the society have to be identified by the decision makers. This is a very important aspect. If you decide that one particular backward community in the country needs only this much help, that might not be sufficient for another community which might need a different kind of help and might be more assistance. So this diversity of the country is an important aspect which has to be understood by not only the lawmakers but also the administrators in the country. That's a very important aspect of diversity. And the last and the most important principle amongst the 5 principles of social justice is human rights. As I said, there is social justice divided into distributive as well as retributive. This country has been experiencing the division in society on the basis of varnas to start with, and thereafter castes. How is it that we achieve equality, which is the most important right that is given to every individual in this country? That would appear a far cry unless the human rights of every citizen in this country or groups are protected. The statistics show that in the United States of America, most of the convicts are blacks. In this country, you would see that most of the criminal cases are only against poor and underprivileged people who cannot even come out on being released on bail by providing sufficient security for being released on bail. People whose rights, which are fundamental to their existence, if they are not protected, then we cannot call ourselves a civilized country. If all these 5 principles which I have spoken about, which were those which were very dear to the heart of Justice Iyer, who had said a number of times that unless persons belonging to the impoverished sections in this country are provided succor, then there is no meaning to ourselves calling this country to be cherishing human rights as well as talking about democracy. And the success of the Constitution lies in achieving the principles that are laid down in the Constitution. Now, coming to the point as to whether the social justice jurisprudence which Justice Krishna dreamt about and which he implemented as and when he was a judge and even after his retirement as a judge. What is it that the judiciary has done to carry forward the ideals of Justice Krishna of imparting justice to the needy sections of the society who are living in pecunious and impecunious lives and living in poverty. There is a misnomer that courts, especially constitutional courts, are not places where justice would be done to persons who cannot afford to approach the court, and that the courts only cater to the litigation that is initiated by people who can afford senior lawyers and people who have a lot of money to spend, and then luxury litigation being entertained by the courts. I should tell you, ladies and gentlemen, that that's not a correct perspective at all. I'll just give you a few instances of how the judiciary has tried to carry forward this goal of social justice as imbibed in the Constitution of India and the dreams of Justice Krishna. Access to justice is a very important right which Justice Kirshnaiyer was speaking about. Even in his books, he has referred to how access to justice is very important. How do you provide access to justice to persons who cannot even afford to travel to the capital of the city or to any other court and then voice their grievances? This was being done through public interest litigation groups, bringing to the notice of the court about the concerns of people who have been suffering because their basic needs are not being met. This tool of public interest litigation has primarily worked very well, though it is misused for other circumstances. I should say even today, public interest litigation has been coming to the rescue of persons who really need a helping hand from constitutional courts. There are several cases where the judiciary has come to support people who are suffering without access to resources. What are those? The basic need for people is right to food. In PUCL, which case was taken up after the starvation deaths in one or two states in this country being in large number in the early 2000s, the Supreme Court gave directions by holding that right to food is an inseparable part of right to life, which is guaranteed to all citizens in this country under Article 21, to everyone, not only all citizens in 21. A number of schemes have been formulated by the government by which food is being provided. On one hand, the complaint was that the granaries are full with food grains. On the other, you have so many people who are dying. But ladies and gentlemen, that the statistics show that in the global hunger index, in a country of 103 people, we are 97th.
Hi, sir. I think there is some technical difficulty from Justice end. We'll get in touch with them in a minute.
Yes.
Dr. Pradeep, what is the reason?
Yes. Some technical problem from the side of Justice Nageswara Rao, sir.
Suresh, I think I've lost the connection. That Wi-Fi problem.
It is working, it appears.
I think sir is back. I think there was a power cut or something.
Yes, sir.
Yes.
I hope I can be heard now.
Yes, sir. It's okay now, sir. It's okay.
Sorry, I think there was a disconnection. Even in the year 2020, we are facing a situation where about 7,000 people died due to starvation. A staggering number of 25 lakh people died due to starvation without food not being available to them. Next comes livelihood. Right to livelihood has been declared to be an integral part of right to life in Bandhuva Mukti Morcha, which has led to several schemes that were framed by the Government of India, including the MNREGS scheme, apart from so many schemes framed for providing employment not only to the rural youth, but to the other persons who are ready to work, because right to work itself is an obligation on the part of the state, as has been adumbrated in the Directive Principles of State Policy. Chameri Singh recognized the right to shelter to be a part of right to life. Right to health of every citizen in this country has been found to be the duty of the state, which they have to take care of in Vincent Panikur Langara and Paschim Banga Khet Masturi. Right to education was dealt with in Krishna and DMFI, where they have said that every person in this country should be given an opportunity to receive education and also to develop themselves as responsible citizens of this country. Apart from all these judgments, there are several others which I can refer to, where the judiciary has been taking an active role in providing the immediate needs of the persons who are not getting benefits under various schemes. How do we do that? The problems of children, mainly in street situations, problems of sex workers and other marginalized sections of the society, including those who belong to LGBT community and transgenders, have received the attention of the court, by which, in judgments by which their rights have been recognized, their existence in the society and their cry for equality has been held to be a very precious right which has to be protected. Women's rights has been of serious concern, which has been taken note of by the court, by several judgments of the court, where the court, which was aware of equality and the principle that has to be implemented, which is guaranteed by the Constitution, has spoken about the document which is the Constitution of India as a transformative document where the society should be taken forward. The question now is, have you done enough? I've been telling you that the judiciary has been playing an active role in upliftment of people by providing them they are equal participants in this democracy. Justice Gajendra Gadkar wrote a book called Law, Liberty and Social Justice. He says that there are 5 giant evils: want, desire, disease, ignorance, squalor, and idleness, which thrive on the fundamental evil of poverty. The first thing is to get rid of poverty. How do we get rid of poverty in such a vast country with the resources which are limited? It is very easy for people to say that it's almost an impossible task. Getting rid of poverty is not very easy. We are talking about a democracy which has certain ideals to be achieved, which have certain goals which also have to be achieved. Providing for the basic needs to the downtrodden and depressed sections of the society would at least get rid of poverty, for which I think this country definitely has the resources. And to provide people with equality of opportunity and provide them a right to development, which is a very important fundamental right and a human right that is guaranteed to every citizen of this country, would ensure that there would be an egalitarian society. Ladies and gentlemen, there is fraternity which you find in the preamble of the Constitution. The preamble speaks of fraternity assuring the dignity of individuals. Fraternity is to come from within. All of us have to think about this fraternity, which is not spoken much as people talk about liberty and equality. Universal brotherhood is an important goal of the constitution makers. To fulfill an egalitarian society, we should shed these unwanted ideas of division of the society on the basis of caste, on the basis of religion, and on the basis of region. Unless all of us adopt an approach which is the promise of the Constitution of India, that all Indians would be treated equally without any person having a vociferous tendency of trying to promote only a person belonging to his group, but also ensure that all persons in the society who need succor are taken care of and given a helping hand to bring them on par with the others. Right to equality, which is an important right in the Constitution, can never be fulfilled. Justice Krishnaiyer's dreams of making this country an egalitarian society where all citizens would be treated as equal would be fulfilled only if all of us, the citizens of this country, understand the difficulties of the underprivileged sections of the society and help them in becoming equals. Thank you very much.
Thank you, sir. Justice B.R. Kirshnaiyer, the legend in law, is being remembered through his classical judgments and legal literatures. Today, in this 7th Memorial Law Lectures, we are blessed with the presence of Honorable Chief Justice S. Manikumar, who presided over the function. We acknowledge our deepest gratitude to you, sir. Knowledge and legal updates, which we are getting through reading and hearing the lectures. Honorable Justice Nageswara Rao has explained and analyzed the importance of social justice in its jurisprudential aspect, referring to the contribution of Justice B.R. Krishna. This is a worthy tribute to our founder. We, the foundation, acknowledge our deepest gratitude to you, sir. Judges, lawyers, law professors, law students, and other personalities from public life, they have joined for this session today. The foundation acknowledges its gratitude to all of you who gathered for this live session, the live law and the technical team who supported us to complete the session without any technical lapses or issues. And we acknowledge our gratitude to the live law team as well as its technical team. And we are concluding today's sessions, and we will meet next year with the 8th Memorial Law Lectures with another subject, then another great personalities as a speaker. Thank you all.